Larry Carnes, did you have anything else to add? You were up yesterday, and I don't want to cut anybody off.
With respect, I think I've made the points I wanted to make. I'd be happy to respond to any questions, or I know there's a lot of people here that want to testify, and I don't want to eat into their time.
We'll hold, and then if there's more questions, you can help out.
Happy to do so.
Rochelle Colombo was written. Allie Devine. We're opening the hearing back up on the opponents of 137.
Mr. Chairman, I'm Allie Devine, as you said. May I begin?
Go ahead.
Thank you. Mr. Chairman and members of the committee, thank you. My name is Allie Devine, and I'm representing the Kansas Society of Land Surveyors. And before I go into that testimony, I want to give you a little background information I think may be helpful to you. The first of which is somebody asked about the history of the military exemptions and the things that have done on licensing for the military. If you go to the Kansas Research website, they have a whole section in 2014. It's called the Legislative Briefing Book that has a whole background of that particular issue. For additional information that I thought was really helpful, and it's the National Council of State Legislatures. They have done a pretty good background survey of information. They had working groups around the state, our nation, and their #1 issue was to address the military aspects of licensing. So that's available. Mr. Chairman, I failed to ask, how much time do we have?
As much time as you need.
Oh, not that much.
But I'd like for you to go quick if possible.
Okay. Anyway, I want to set that out there just for a second. With me today, I think, is Jason Johnson. He's from Concordia. He was going to be virtual. I don't know where he is in the universe. If you have specific questions about surveyors, he's the guy to answer those. I'm going to keep all the testimony on kind of pretty much the focus of the bill and what the surveyors are concerned about and how we think it could be improved. I want to also make a point to you, a couple other upfront things. This bill is not like the bill that was in the Senate last year. If you pull up the substitute or the background piece on Senate Bill 366, you'll find out pretty quickly the supplemental note is similar, but not the same as this year's bill. Last year's bill was focused on the military. This bill goes beyond the military to civilian licensing issues. It is not exactly like House Bill 2066. 2066 in the House is being considered, and it has a number of amendments that are not included in Senate Bill 137. So just for big picture again, we want to make clear that we do not, the surveyors and their people across the state do not oppose special provisions for military. They welcome and would welcome a discussion about how those things can mesh together. I had a call with them after I read this document about what they've done in other states about taking the military qualifications or things that had worked in the military and applying them in the state civilian side licensing. And they're willing to talk about it and work with it. So with that, I want to just walk through the testimony you have in front of you. You'll probably wonder, why are we here? There is nothing more fundamental in Kansas, in my opinion, and the opinion of anybody who owns property, than a property line and legal descriptions. They have to be accurate. That's how we defend our private property rights. We think it's really important that persons coming from other states, especially those east of the Mississippi who operate on meets and bounds descriptions, understand longitude and latitude descriptions in Kansas. We are a different animal in survey work and in legal work and legal descriptions. They are east of us. And in many states, surveyors are not licensed. So here they are concerned because in the first page, you'll see the outline of the training that they go through to become a surveyor. And again, it's three things. I'm not going to read this to you. It's three things. It's testing. It's working with somebody. It's doing like an apprenticeship opportunity. It's 3 years you take a test, another 3 or 4 years you take another test based on your experience. So you have 8 years of experience, and then you go for the final test. These are not transactions that are easy. They have to be earned, and they see it that way. Again, why do we care? Because financial records, mortgage documents, property rights, estates, everything that we hold about how we operate is dependent on getting those basic documents correct. So, when it comes to do we recruit, do we try to bring people, we get the sympathy for wanting to bring people into work. They have been doing that. I outlined in a paragraph that they've gone as far as working with the Kansas City Community College to set up a program to help people, A, understand what it is, and B, participate in it. So those things they've done, they've gone to Boy Scouts, they've gone to high schools, trying to recruit people to be interested in this field. So why are we opposed to this bill? The overarching issue is this. There are things that this legislature has deemed important enough that it requires a license. There are not just one or two, there are hundreds of them. If you go to the statute books and you pull out the index and you look at licensing, there's going to be a long line of people, of occupations that require a license. Way down in there, you're going to find surveyors. And because of that, because of the trust the public has in those credentials, is why we think it's important that there be oversight of people coming into the state. You can say that this bill just brings people in. It does more than that. Proponents would like to say that there's always a stop. There's something that the licensing authority can do. The plain reading of the bill will say that is not true. And here's why. You can go to various clauses. And one of the pieces, and I can go line by line if we need to, but a lot of the qualification requirements are held in section 1CA, 2A, where that's where the qualifications are hooked. In section E, where they talk about bringing in people and licensing them based on their work experience, that qualification piece no longer applies. The same is true in F, where you have certifications from out of state. They've set aside that qualifications piece. Why does that matter? It's because without that qualification piece, there's no way for a licensing authority to stop because they're mandated to issue a temporary license followed by a permanent license. What does that mean? So here's the piece. The state of Kansas, in parts of this bill, are saying, we know you're unqualified to work in the state as this type of occupation, but we're going to go ahead and give you a temporary license, and we'll let it run for 6 months and give you time to get qualified. What if they don't? There's an automatic piece that calls for them to get a permanent license at the end of it. The only real check is if the issuance of that temporary license is tied to public health or safety. Now, I got to tell you, if you put a building on the property line, it's probably not going to be a public health or safety issue, but it's going to cost somebody a lot of money. Some failure of a surveyor will result in a financial loss. The Board of Technical Professions don't have the flexibility under this bill to give protection of the public of that piece. What we have suggested in the House is that they add some clause, wherever they use the clause public health and safety, we talk about protection of property. I've offered financial information. Whatever the language is we can agree on, We've got to broaden it beyond the health and safety aspect to those trades and professions that deal in things that financially we rely on. So in summary, Mr. Chairman, there's a couple things that are really critical. One, we can't support a bill that ultimately diminishes the value of the work people have done to get a license. And here's why I say that. We could have somebody come to Kansas, get a temporary license, and go back out. And they may stay in Kansas or they may go somewhere else. Eventually, when they try to take that license that they got in Kansas and go get another license in another state, that other state's going to ask the tough questions. What was the review that was done in Kansas? What happened there? And when they find out that we issued temporary or permanent license with not equal to standards, not equivalency standards, they're going to say, we reject this one. And by the way, all your brethren coming behind you are probably going to have the same problem. This takes the work of those who are here and devalues their work to where they're going to have to compete on the lowest level possible and probably won't be successful. Other things that's bothering, traditionally in licensing law, it is up to the proponent to come forward and show how is it that I am qualified to take the public trust. When I took my law license, and none of this is here, the best day of my life was the day I graduated from law school, and the second best day was when I passed the bar and my husband did at the same time. That would have been ugly if we hadn't. But at the same time, we made a commitment to uphold the laws of the state of Kansas. But not only, we had a public obligation to tell the truth and to talk about it and to not mislead people. If the state of Kansas says, okay, you can have this license, you're saying to the rest of society, this person is qualified. When my father died, we hired a number of professionals. We hired a surveyor, we hired an appraiser, we hired a mortician, and ultimately we're probably going to hire a real estate agent. If any one of them is not qualified, what is my recourse? Well, my father would have said, well, God, I got all these lawyers in my family. Surely one of you can figure it out. And the answer is yes. But the value of that license is not what I'll go to. We will have to go at them at civil liability. And as their professions, normally they would stand up and say, hey, I meet the qualifications of the state of Kansas. And my response would be, do you? And when did you? And this puts all that in doubt, in my opinion. The next thing is, I think it's important to remember part of the idea was to bring people here. I hope it's also not the reason people leave. Because when you have spent the kind of time in 8 years of developing your career, and then you have somebody else comes in who has less credentials, but still projects themselves to be equal to you, what has that done to you in your profession? I think many of them would say it doesn't help us. So with that, Mr. Chairman, I'll be happy to answer the questions.
Okay, thank you. We'll hold questions till the end of all the opponents. Aaron Dunn, are you online, virtual?
I am. Can you hear me?
Yep.
Thank you. Mr. Chairman, members of the committee, thank you for the privilege of testifying today. Name is Aaron Dunn again. I'm with Allen Gibson Hulick. I'm a CPA and our chair of the Kansas Society. And on behalf of the Kansas Society of CPAs, I come to you today in opposition of the bill in its current form. We in the society and our firms all believe that job creation and workforce development is very, very important for the state of Kansas. We're concerned about the unintended consequences of this bill. And just as a little bit of background, when I talk about scope of services here, the state of Kansas has basically a profession of accountants, and then we have a profession of certified public accountants. And accountants can do bookkeeping, tax prep, payroll services, things like that. Those folks are not regulated in the state of Kansas. Certified public accountants are regulated in the state of Kansas. And to become a CPA, many of you probably know, you have to pass an exam, a uniform CPA exam. You have to have education requirements. You have to gain an adequate amount of experience. And you also have to pass an ethics exam. And so the reason I talk about this is because as a CPA, we're vested in protecting the public's interest. And one of the ways specifically that CPAs do this, that only CPAs can do, is the attest services. And a common example of that would be a financial statement audit. Some of you probably know about those. Only CPAs can sign a financial statement audit. And why is this important? Well, those financial statement audits and reports are relied upon not just by owners, but by bankers in making lending decisions, bonding companies in making surety decisions, the investing public when they make investment decisions, employees, customers, vendors, other folks up and down the supply and sales chain. And so having somebody sign an audit report that's licensed but not substantially equivalent is a significant public concern for us. The state of Kansas actually has mobility and a system of reciprocity based on the concept of substantial equivalency for CPAs. The current system that we have in place is working really well for the state of Kansas and other states, and does not present a barrier to those entering the state of Kansas that meet that substantial equivalency. So in other words, we already have a system that's working quite well. And what I've been told is the Board of Accountancy, when they get those reciprocal applications, on average, can turn those applications around in about 24 hours on average. And so to be brief, the KSCPA's position is aligned with the Board of Accountancy on this topic. We have a significant concern about protecting the public interest when it comes to becoming and performing duties as a CPA in the state of Kansas. We're uncomfortable with the potential licensing of CPAs who do not meet the substantial equivalency requirements. But however, if the bill is to be amended by including the Board of Accountancy in subsection S, which would allow the Board of Accountancy to continue to do its evaluation of substantial equivalency, we would possibly remove our opposition to this bill. We just don't think it's a good idea to license individuals that are not substantially equivalent to the CPAs in the current state of Kansas. And again, I want to be brief, so I'll go ahead and stop there. I do thank you for the opportunity. Unfortunately, I have a previous commitment I'm going to have to step out and go to, but I'm willing to take email or phone calls from anybody if they want to discuss or have questions.
We'll get back with you one way or another. At 15 after, I'm going to switch to another bill. So everybody that's testifying, you want to give the members some time to ask questions. The last opponent that is virtual, Dana Williamson. I don't know if I got that right.
Can you hear me?
Yeah.
Okay, perfect. Well, to be brief, my name is Dana Williamson. I'm a licensed architect here in Kansas. I own the only architecture firm in Dodge City. I'm representing the American Institute of Architects Kansas chapter. I just want to reinforce all of the opposition comments. I'm born and raised Kansan. I chose to raise my family and run my business here. I want to see others do the same, but I think some of the language in this bill is a little bit irresponsible when it comes to public health, safety, and welfare. And as an architect, yes, I did have a rigorous process in licensing, obtaining my license, but we already have a system of reciprocity set up that I think works really well and ensures the competency level remains the same for someone who acquired their license here in Kansas or coming from out of state. I believe in my testimony, we talk about our recommendations for amending this bill. If you would want to refer to that. And with that, I will just stand for questions and let other people.
Okay, we have one more written piece of testimony. Do we have questions?
Mr. Chairman, this is Tom Holland. At some point, I'd like to ask a question.
Go ahead. Senator Straub, was there someone else on there? Okay. Yeah, Tom, you can ask questions too, but Senator Straub's got the floor, so.
Thank you.
Thank you, Mr. Chairman. My question is for Allie Devine. In the section of your testimony, Path to Career in Land Surveying, you say that there's 3 parts, 3 tests that a surveyor must pass, and both of the first 2 are National Council of Examiners for Engineering and Surveying. Are those required by all states?
I don't know, but if Jason's on, he could answer it, and if he can't, I'll get it right back to you, okay?
This is Jason. Can you hear me?
Yep.
The 2 tests, the 2 tests that come from the NCEES are national tests that anybody in any state of the United States would take. And then the third is this Kansas state specific portion of that.
Thank you. That was the clarification. But then in follow-up to that, so the third part is really to understand state statutory and case law. Don't we have attorneys for that?
I'm not sure I follow what you mean, but the Kansas, in my experience, the Kansas state portion of the test deals specifically for specific situations that arise in doing surveys within the state of Kansas that may differ from our surrounding states, either via statutes or our individual state minimum standards for practice. Does that answer your question?
Yes, but I guess my disagreement is, why are we requiring land surveyors to essentially be attorneys? That's what we have attorneys for. I understand that the 2 national tests are in the practice, but the understanding of law should be for the attorneys to decide, not for the surveyor. The surveyor should be providing technical, accurate measurements and descriptions. It's up to the attorney to decide how that's handled within law.
Go ahead, Ally.
Mr. Chairman, sometimes a case may have a ruling on an interpretation of a particular description, what its meaning is. So as they draft the legal descriptions, they'll need to incorporate those changes. So as I did title work for years, so those surveyors, when they put the surveys together, they write portions, if not all, of the legal descriptions.
Senator Holland?
Okay, thank you.
Thank you, Mr. Chairman. I do have a question for Allie Devine, if she would stand. And I do want to make a brief comment, though. And I think particularly by the testimony from the 3 opponents this morning. Before I ask my question for Allie, just a quick comment. One of the big concerns I have with Senate Bill 37 is that while it refers to these boards that will be doing this basically evaluation, we really have no definition anywhere in the bill of specific job occupations that are impacted by this, nor do we have a clear idea about how many Kansans are currently licensed or certified under each of these positions. And while there may be some fig leaf of comfort in the 137 that talks about, well, if it's in the public safety, health, and interest, then you don't have to, grant this exception. I think just by the very minimal conferees we've had in opposition, they've given me a whole new concern as far as some of these other non-health safety related positions, just the chaos potentially that could ensue if we're bringing in people in the state that really aren't qualified to do this type of work. But my question to Ms. Devine would be this. Allie, you've been around the Capitol a long time. before I was ever in government, I came here basically in the early 90s. And I think back at that time, Governor Brown, who was governor at that time, actually, I think he was the state ag commissioner. I think you probably worked for him in his office. I just kind of curious, just give me a bigger perspective on, and I think you were getting into a little bit in there, and I appreciate those thoughts, but just give me just give me a bigger perspective of how sweeping this is and really how this may have how this is different basically than issues we've seen in the past. If you had any perspective on that, if you don't, that's fine. I'm just curious to get your bigger long-term perspective on that. Thank you.
Go ahead, Ally.
Mr. Chairman, I think this bill is very broad. Last night, I went back to check some thinking to make sure I wasn't understating or overstating anything. The things that I checked are some of which have been talked about are architects, auctioneers, barbers, stylists, accountants, engineers, dentists, dental hygienists. I'm not sure whether this bill includes commercial driver's licenses. In other states, they've pulled that issue in. I don't know that that's the intent because they use the term professional occupations, but I think if you ask some commercial truck drivers, they would very much say they're commercial professionals. That's something that needs to be discussed. Insurance agents, interpreters, optometrists, pesticide applicators. This is one that I'm very familiar with. Those people who come into your homes and spray bugs, they all have licenses. A friend of mine asked me, Allie, does this cover aerial applicators, pilots? Those are all licensed entities. So without going down the alphabet, it's very broad, and it is not consistent with what I have seen in prior bills. And from a pure licensing, the licensing aspect of government is part of the police powers, and it is what conveys your authority to govern. Over the years, a lot of legislators and a lot of legislatures have looked at these professions and said, these are things that need to be regulated.
Yeah, I mean, here's my way in. I mean, this bill needs considerable work to be ready. I mean, it kind of reminds me of a bill a few years ago. And, there's a lot of different entities. I definitely, my uncle was a surveyor, so I've dropped a plumb bob or two over the years. I definitely understand, how you could get a building on the wrong structure if someone wasn't qualified. And there's things in Kansas that don't apply to Missouri or Texas or other states that just apply here in Kansas, how statutes. Senator Holshore, go ahead.
Sorry, I didn't mean to interrupt you.
No, go ahead.
And maybe this will be answered coming up, but as I listen to the different testimony, I'm just curious, and I don't quite know the right person to ask this question of, and maybe it goes to David doing the neutral, but compared to other states, does the licensing process in Kansas take an inordinate amount of time for specific industries? Because that's what we're talking about. The heart of this is speeding up the process. So it sounds like from some testimony, we have some industries that move it along pretty quickly. So I guess that to me is my biggest question is, are there areas where we're taking a lot more time than others? So like I said, if there's somebody here that feels that's a question they can answer, or maybe it's a David question, I'm good with whatever.
Go ahead.
Again, I'm Larry Carnes with the Technical Professions Board. We turn reciprocal license applications around just in a matter of a few days. I don't know who's experiencing these long delays that are being referenced, but they're not in our professions. One last point I want to make while I've got the floor, and that is this escape valve that they talk about, that we can deny a license if we can show that it would be dangerous to the public health and safety. That's an ominous burden for us to have to show that issuing someone a license that they're dangerous. How do we know if they're dangerous or not? We can tell if they meet qualifications or not. And that's why that particular provision is not sufficient to protect the public. Thank you.
Okay. Yeah, you got to follow up. If not, I'm going to move on to the neutrals because I want to get some of these other bills done that were scheduled. David Sulfur? I'll get it right one of these days. Sulfur?
You're good, Mr. Chairman. David Sofer, Legislative Policy Director, Kansas Department of Commerce. Appreciate the opportunity to testify today. So we are neutral, but I want to clarify a little bit what our position is on occupational license reciprocity. We support the policy. It's not often I actually get to be on the same side as my friend Elizabeth with the Americans for Prosperity, but in this case, we get to. This is actually an exciting opportunity, but because license reciprocity is so incredibly important, and let me kind of explain why. You know, I think it was touched on yesterday is a lot of Kansans get to, they dedicate their career, they put their, everything they've got into their career and so they spend that time getting into that license. Often what's not thought about though is as we want people to continue to come to Kansas, those same people have dedicated that same time in their state that they're coming from. And so to have people that come to our state, whether you be a military spouse, which I'm hopeful we can all agree is a slam dunk, we have to be able to take care of this so our military spouses have those licenses because those are the people that as our folks, as our military members leave service, we want them to stay here. Those are incredibly great individuals, great families that we want to have as, and make Kansas their home long term. So I'm hopeful we can all agree on that. But as far as why, it needs to go beyond military spouses, as we want folks to come here, we want them to be able to get to work immediately. That's one of the most important things we're seeing today, especially as we're dealing with, the like of the pandemic and everything else. If there's opportunities there, we need to be able to speed up the process, get them to work, get them be able to earn a living. Otherwise, we're losing people because they don't want to come here because they can't get to work immediately. That there has a tremendous effect on both their families, their ability to provide, and long-term if they're not able to get to work. So, while I understand there certainly are some agencies that do it better than others, and we've worked with the sponsor, and that's why we're neutral on the bill. This bill does need quite a bit of work. On the House side, there was an amendment that took care of some of these issues. My understanding is there's another balloon amendment when it comes to the floor that will take care of quite a few of these other issues that have not gotten to yet because we do need to clarify some things also from our end. We were not necessarily comfortable with some of the telemed items that were in there. So that has been taken out on the House side, and certainly we would encourage the Senate to do the same. But from our end, if we have an opportunity here to get people who are qualified, who may not meet the exact requirement 100%, but they're 95% there, and we can get them to work while they meet those qualifications, that to us is a great policy. It gets people working. It's workforce development, economic development. So from our end, this is a great starting point. We do hope to get this bill done. We certainly would encourage you all to work on it and get it moving forward. But as of right now, with the bill as it is currently, we would have to remain neutral. And with that, I do have to run, so I apologize. But if any committee knows how to get me, it's you all. So certainly I'll be happy to stand for any questions, although I might be back here by the time the neutrals are done. So if I am,
Good.
I'll be happy to stand for any questions.
I hope you're not back before they're done. I want to get moving on.
Thank you,
The next one, Scott Kane. I don't know if you're here. Okay.
Thank you, Mr. Chairman, members of the committee. Appreciate the opportunity to appear before you today. My name is Scott Crane. I'm a licensed professional engineer working for Affinis Corp., a Kansas company which provides professional design services. I appear today in my role as Government Affairs Chair for ACEC of Kansas. ACEC Kansas is a trade association representing private consultant engineering firms doing work in the state of Kansas. Our members stretch from Garden City to Kansas City and includes both large and small firms. We're here today to encourage your support for the amendment suggested previously by the Kansas State Board of Technical Professions and subsequently by Kansas Society of Professional Engineers. This would add engineering to subsection S of the bill. I'll not repeat the information previously provided. I want to confirm that the engineering firms in private practice in Kansas share the serious concerns articulated earlier. Our firms design infrastructure across the state, And the highest focus of our work is always the health and safety of those who use that infrastructure. Knowing that a licensed engineer who designs and stamps plans has the qualifications to do so in a safe and competent manner is paramount to our business. I'd like to emphasize that we do not oppose the overall intent of this bill. It is common in our industry that someone will work on a project in another state, and inefficiencies and delays in licensing reciprocity can add costs and delays to much-needed projects. However, improving that process should not be done in a manner that could result in engineers who have not demonstrated the proper qualifications being granted the right to stamp plans, which could have enormous consequences to the health and safety of our citizens. From a business standpoint, the potential liability to our companies of such a person designing and stamping plans, which prove inadequate, would be enormous. Currently, when we hire someone who's a licensed professional engineer in the state of Kansas, whether they obtain their original license in Kansas or were granted their license through reciprocity, we know those engineers have displayed qualifications to protect the public health and safety. In its current form, SB 137 would diminish that certainty, increase liability, and raise the risk level to the users of our infrastructure. If the suggested amendments adopted, ACEC has no opposition to this bill. We'd be happy to confirm and communicate that the situation has been successfully resolved. Thank you again for the opportunity to appear.
Okay, thank you. I'm going to go ahead and call Travis Lowe. I didn't have you on the list, but were you a opponent or a neutral?
Thank you, Mr. Chairman. We'll be neutral.
Okay, we gotta
real
really keep this going.
Yes, sir. Thank you. For the record, my name is Travis Lowe of the Braden, Heiner, Lowe & Associates firm, here today representing the Kansas Society of Professional Engineers. Since 1910, KSPE has represented the professional society for licensed engineers. We do support the underlying intent of the bill to have licensure expedited very quickly for new residents and military. Having said that, our intention is to make the committee aware of what we do see are anticipated consequences as relates to professional engineers, and I'll be extremely brief on my points. As the bill changes to similar scope of practice, this creates a problem because licensed professional engineers do not have a scope of practice in statute. Unlike a dental hygienist that says that these are the procedures that you can perform on your license, we do not have that for engineers. They operate within their scope, just like an attorney does. It doesn't say what an estate attorney can do or what a defense attorney can do. Moreover, unlike a pharmacist or a dentist, we have a licensed and an unlicensed workforce, much like the CPAs. And so many people that have an engineering degree work great careers. The other portion of the industry went through the 8-year process to become licensed, and Kansas statute is peppered with authority for those licensed professional engineers on industry project oversight, holding other key roles. And the difference is that qualification. So is that if no longer the measuring stick, that reduces the two lines between the industry. Also, as relates to the reciprocity, page 2, as it mentioned earlier, says that if a person comes into Kansas and they are not qualified to, under the reciprocity statutes, line 29 says they shall become licensed, and line 40 says because of similar scope of practice. That relates back to our other concern. Yesterday, a proponent made an example about the PEs that come in from another state, and the test was referenced just a second ago. There are examples where, yes, it's a national test, but some states, for whatever reason, grant waivers. So there are PEs out there that haven't taken the national test. That's not allowed in Kansas, but it would be in other situations. Also, education, you have to have upper-level math, Calc 2, Calc 3. There's some degrees that don't allow that. But then most importantly, this did become law in Missouri last year. We do know firsthand that all these examples I just provided have already happened in the first 6 months of enactment in Missouri, where PEs have been licensed in Missouri by not way. Someone that lives in Joplin goes to Missouri S&T. They don't have the education requirements, and so we do appreciate the opportunity to have a subsection S as an amendment that would exempt, or not as exempt as from the bill, but allow us to continue measuring qualifications. And Mr. Chairman, I was trying to be extremely brief.
Thank you. We're just out of time. I mean, there's a couple more, but I'm going to move them to written. And if there's a couple questions, I'll allow that. But if, do I have any questions? Not seeing any. Okay, we're going to go ahead and close the hearing on 137. We'll go ahead and move over to the hearing on 161. Chuck, so anybody who wants to leave, 137, we've closed that hearing. Chuck, can you go ahead and give us an overview on 161?
Yes, Chairman, I will do so, and I'll try and be brief. This bill was before the committee last year, Senate Bill 435. There was a hearing, and it did pass out of the committee, but died on general orders. Specifically, Senate Bill 161 is brought to you by Amazon. It permits the personal package delivery devices, and that's defined in the bill, to operate on sidewalks and crosswalks for the transportation of property. Personal delivery device means a powered device operated primarily on sidewalks and crosswalks and intended primarily for the transport of property on public rights of way that does not exceed 150 pounds, excluding cargo, and is capable of navigating with or without the active control or monitoring of a person. These devices have to have the ability to stop, detect, and avoid objects and be actively controlled by an operator, although they operate independently. The devices must obey all traffic and pedestrian control signals. Generally, they have the same right-of-way obligations and responsibilities as a pedestrian. The bill provides that these delivery devices are not to be defined as motor vehicles under Kansas law and are exempt from motor vehicle registration requirements. They are not considered a vehicle under Kansas law. There's a requirement of general liability coverage of at least $100,000 for the operators of these vehicles, devices, excuse me. They cannot transport hazardous materials. Local governments may prohibit the operation of the devices if the local government determines that prohibition is in the interest of public safety. And that is generally what the bill does.
Hey, questions or comments for Chuck? Not seeing anything, Chuck. We'll go ahead to Jeff Cleveland, Amazon. Are you online?
Yes, can you hear me, Chairman?
Yep, we can hear you.
Great. Thank you, Chairman Olson, and members of the committee for the opportunity to participate in today's hearing. My name is Jeff Cleveland. I lead state and local transportation policy at Amazon. I have submitted a written statement in support of SB 161 for Scout, Amazon's fully electric autonomous delivery bot that operates in pedestrian areas like sidewalks and crosswalks. So I will keep this brief. Some things have changed since last year's bill passed the committee. Scout's now delivering in 4 suburban communities: Snohomish County, Washington, Irvine, California, Atlanta, Georgia, and Franklin, Tennessee. Also, more than 12 states in the District of Columbia have now passed personal delivery device legislation, which allows us to operate in more states, and more will follow in 2021. Suburban sidewalks are some of the least utilized infrastructure in certain regions of the country, and we find that Scout is a safe, innovative, and environmentally friendly last mile delivery option. Scout is 100% electric and helping Amazon drive towards our goal of making all Amazon shipments net zero carbon, with 50% of shipments net zero carbon by 2030. Thank you for the opportunity to share more information and support this bill. And please let me know if you have any questions about Scout.
Okay, we'll hold questions till the end of the proponents. Evan, 1-2, FedEx.
Yes, sir. Thank you, Chairman. Evan Oneto with FedEx Corporation. Here to testify in support with also a request for some key amendments. On behalf of the 4,500 FedEx team members in Kansas and as a proud member of the Kansas Motor Carriers Association, we're here to support SB 161, but we have a few requested key amendments without which we would be unable to operate in the state. The weight is smaller and lighter than FedEx's delivery bot, Roxo. Our bot is based on designed by DECA, who created the Segway. It was designed for paraplegic veterans returning from war, and the idea being that it can transcend like a flight of stairs, potholes. It's a little more robust than your average wheelchair. Because of that base, it's a heavier base. It has gyroscopic technology. It has a number of safety redundancies that make it a little heavier. Without that weight change, we would be unable to operate in the state of Kansas. Additional amendments we have requested is the ability to operate on the shoulder of a road when and where is safe. Our goal is to be able to deliver goods, not just in the downtown areas, but into some of the surrounding suburban areas where is possible. Roxo is currently designed to have a radius of about 5-mile delivery radius. So we're looking to expand that reach if possible. And then lastly is the speed. The standard speed limit in other states where this is passed has been 10 miles an hour on the sidewalk, where of course, when and where is safe. So we've requested that as well, along with some additional technical amendments, but those are the main ones. And a couple of things I'd like to talk about what ROXO does not do and will not do, and that is affect or decrease workforce in any way. It will only serve to add to the workforce that we already have in the state and every other state we're already operating in. We have remote operators that will be on standby to guide and watch its operation to make sure it's functioning properly and safely. They will be on standby to monitor any systems. So those are additional employees that do not exist today. Additionally, FedEx Office will have to acquire support personnel that can service these bots when and where maintenance issues arise. And so that, I think, is important to note, that this will only serve to add to our workforce. With that, we are very excited to bring this technology to Kansas. It will expand our same-day delivery service. And that is also, I think, an important key to understand, is that this in no way will interact or interfere with any of our current delivery services. This is really a new revenue driver for us, in that it'll be same-day delivery services with your local retail. So we think this is an important tool for Main Street to be competitive in these uncertain times. Without these amendments, as I mentioned, we'd be unable to compete. And we think that Kansas should support a regulatory framework that allows for the maximum amount of competition and innovation while providing for public safety. And we think these amendments achieve that. With those amendments, we would be more than happy to support this bill. And I'm available for any questions if any member of the committee has any. Thank you.
Are there any further proponents? Not seeing any questions, comments? Senator Peck.
Thank you, Mr. Chairman. In section 1 on line 18, it talks about these devices operate primarily on sidewalks and crosswalks and intended primarily for the transport of. So how do we have assurance, and what does primarily mean? I understand that the intent is that they remain on sidewalks and crosswalks, but when you put the word primarily, that means that they can or will deviate from crosswalks and sidewalks, correct?
Yes.
Are you asking, who are you asking?
Either one of the proponents that wish to answer the question.
I'm happy to take that. In current operations in the 4 communities we're operating in, when we say primarily, the idea is that they're on the sidewalk, but let's say trash cans or a car is parked across the sidewalk, the bot would then have to navigate around that object to get back to it. So the same way that a pedestrian operates in a sidewalk, these bots are doing that, and also operating in crosswalks where they need to cross the street. Again, the same as a pedestrian.
Senator, I would just add the same, that primarily is mainly the idea indicated that when it has to navigate obstacles. The only addition we would ask is that it also be able to operate on the shoulder of a road when and where is safe to do so.
I guess the technology is well advanced compared to what I would see, but on page 2 it talks about obey all traffic and pedestrian control signals. I have no idea how it's going to know about a pedestrian control signal, for example, but I live in rural Kansas, and I would urge you not to send these out in rural Kansas, because you'll
I think they're going to
never
start
find them
down
again.
in Tyro, but I could be wrong.
Well, Tyro's okay, but Havana is a whole different story.
I think if I remember right, last year they showed us a video. There'd probably be a truck. There'd be multiple ones of these that they'd be running up and down the sidewalks. They deliver the packages and return. Someone's remotely working with them. Matt, I don't know if you have anything to add, but I know we had a video look of what they look like and what they perceived. I don't know if there's some place they can go on a website to look to understand the bill. Okay, Senator Hosher.
There's a video online. I'll forward it to other members.
Maybe Send it to Michael.
Send it to Michael.
And then he can distribute it to everybody. We can get the full picture of it. Just being, dealing with COVID this year, they couldn't come in and present in person. So their companies don't allow them. I believe that's the issue. So, you got another question, Senator Peck? I see one coming.
I have all kinds of thoughts and comments, but I will refrain, Mr. Chairman, because this is certainly an urban, large population area issue, and I'm not from an urban, large population area. Havana population is 95.
I thought this would be a rural thing. Come on now. Senator, further questions or comments for the proponents? Not seeing any. Oh, Senator O'Shea, you're good. Okay. Well, we'll move on to the opponents. Matthew Hall.
Chairman Olson and members of the committee. I'd actually like to yield my time to Jorge Quinones.
Okay.
Jorge Quinones is a UPS driver here in Topeka.
Sure.
First of all, thank you, Mr. Chairman. Thank you to the committee for your time and the opportunity to come and say a few words. First of all, my name is Jorge Quinones, and I live in Topeka. I've been a service provider or a UPS driver for 26 years, which this job has really provided me and my family with life-changing experiences as far as economical and the ability to provide and live a good life. First of all, I just wanted to add a few words as far as our industry has, particularly in the Topeka area, we have witnessed an increase of volume due to the regulations of the pandemic, and particularly in the rural area, we have seen a really substantial amount of volume, and until it works, volume creates more jobs. So in my 26 years, we've seen the largest increase of drivers hired in a matter of 3 months. We were able to put 8 drivers, and that's 8 full-time jobs with 8 full-time benefits, and the opportunity for part-timers to have a full-time job with great benefits and retirement protection. We were also able to create 4 new routes in our center, which it's really rare. Usually we could put on 1 to 2 drivers in a year period. We have actually seen an increase of hours per driver between 50 to 60 hours. We were able to create jobs during a difficult time and sustain those jobs with plenty of hours to provide the ability for our members or our workers to make a good living. I just wanted to share a little bit of my experiences. I'm a rural driver, and we've seen basically, for the most part, you probably will go to some of these houses once a week, maybe once every 2 weeks, and due to the ratio of volume and the customers ordering or discovering the convenience of the internet, we actually go to houses every day now. And I have witnessed a lot of customers' appreciation and thankfulness for our service and the convenience of being able to shop online and get their goods delivered without leaving the safety of their houses. I think this bill is a direct attack to a little over 5,000 employees that UPS provide jobs for in the state of Kansas. Our biggest center in Kansas in Lenexa employs almost 3,000 employees. I really feel that this is a direct attack to good jobs, and I feel that this bill would essentially take volume and work away from our guys. Not to mention public safety is also a concern. And thank you for your time.
Thank you. Okay, we have virtual. It's Ralph, Pimetl. Okay, so you're in person, okay. Go ahead. I don't know how to pronounce your last name, so you can teach us.
Chairman Olson, it's Pimentel, Ralph Pimentel.
Okay, thank you, Ralph.
And I'm here to provide testimony on Bill 176.
Okay. You can take your mask down if you want. I mean,
Okay, thank you.
yeah. And try to pull the mic maybe a little closer. There you go.
Okay.
Yeah.
Yes.
Oh, no, we're on Bill 161.
Okay. Yeah, I'm here to testify for 176.
Okay, the next bill.
Okay, no problem.
Are there any other opponents to 161? Okay, neutrals. Eric Satoris.
Mr. Chairman, good news is my legs have not fallen asleep and I made it up here.
There you go.
That's always a good start. All right, well, I know you all still have a large agenda, so I'll try and be brief. This bill is kind of a follow-up to last year's bill, Senate Bill 435, and when that was introduced, we strongly opposed it because it gave no voice to local governments in terms of the operation of these vehicles or them showing up and coming. I'd like to say that Senate Bill 161 is something that we worked closely with Amazon on in the rush of the end of last session, and so Senate Bill 161 is a compromise that we had reached last year with the proponents of, with Amazon as the proponent of the legislation, and so we are neutral on this legislation. I'd say that Senate Bill 161 is already kind of pushing the limits of safety. It allows entity vehicles up to 150 pounds to travel up to 6 miles an hour. The amendment that you heard, that we just heard about yesterday, to move that to 550 pounds and travel up to 10 miles an hour, making those changes absent any cargo in these, so just those flat gross weights, would increase the force of a collision of these vehicles by over 600%. We heard, as I noted, I just heard yesterday from FedEx about a variety of these amendments. There are a couple of things that seem possible, but the weight and the speed both seem well beyond the bounds of anything that we had worked in good faith with Amazon to reach agreement on. There's, within the bill, there's no maximum weight of cargo that can be carried, which is obviously a huge multiplier in force. While these devices will be required to have a system to detect people, pets, and vehicles, whether stationary or in motion, any failure of those systems is going to have a significant impact on who is hit. So I was trying to come up with an example that I think most of us can get our head around. So would you rather get hit out of the blue by a 150-pound bull calf running at you, or would you rather get hit by a 550-pound steer running at you and blindsiding you? And that is a trick question because you don't want to get hit by either of them at either of those speeds. But 550 pounds empty of cargo at 10 miles an hour has the potential to do significant damage. So we think that those rates are pretty high. These would operate on sidewalks. You also heard from FedEx that they wish to allow those to go on to rights of way, which as Senator Peck noted is allowed in the bill. And then further down on page 1, it says they're supposed to return back to the sidewalks as soon as able, as soon as the sidewalks are there. So we're neutral on this. As you consider this, I would just point out, here's what we always counsel cities when they call us and ask us about passing an ordinance about anything. If there's no penalty provision, then you're essentially just being a nice neighbor making a suggestion. And Senate Bill 161 has no penalty provision in it for any of the requirements that you put in this legislation. So anything that's done, there is no provision for the state or anybody else to act on any violation of Senate Bill 161 as it's drafted. But that's food for your thought, provided that Section 3 remains in. We feel that that's good, and we came to a good compromise with Amazon. Other amendments will really cause serious question about us being okay with this, and I'll stand for questions when appropriate.
Okay. You know, we didn't do questions on the opponents, so was there any questions on the opponents a second ago? Sorry. Okay, we'll hold for questions. We do have Trevor Stiles or Dick Carter. Is that not on this bill? Okay. Do we have any questions for Eric?
Mr. Chairman, this is Senator Holland.
Go ahead, Senator Holland.
Thank you, Mr. Chairman. I do have a question for Eric. So just so I understand, as far as the licensing or regulation of these vehicles, these bots, how are they the same as or different, than other commercial delivery services running around doing work in the state of Kansas?
It may be a question for the proponents a little bit more, Senator, but I would say that the bill specifically says these are not vehicles. So I think that's different than a UPS truck or a FedEx truck.
Well, but they are vehicles. So, I mean, I don't understand. Are we giving basically, you know, these vehicles and the owners of these vehicles basically a preferential treatment over other commercial delivery services that have to basically, you know, get their vehicles tagged and pay taxes on that stuff? I mean, obviously, those commercial operators, you know, they're providing wear and tear on the infrastructure. These bots will too, regardless of what the proponents might say. So, what is the where are the proponents as far as having their skin in the game, as far as them maintaining the local infrastructure to run these vehicles up and down the sidewalks and all the other stuff?
Mr. Chairman and Senator Holland, I would maybe leave that up to the proponents. What I would say for us is that within Section 3, allowing local governments to have that dialogue with them and address those concerns allows cities to weigh in on whether the costs are outweighed by the benefits of them.
Well, that's fine and dandy, but I know the legislature also has a tendency to overreach and tell the cities at various times what they can or cannot do. And my concern on this is that if the proverbial nose is under the tent, that basically once these things get entrenched and become pervasive, there is a societal cost. Obviously, there's a benefit to consumers, but there is a societal cost. And I just hope we all understand where we're getting involved with this, particularly when it comes to potentially displacing Kansans out of their jobs. Thank you.
Senator Hosher? I'm sorry.
It's okay, it's good.
One of them days.
I am concerned about the potential displacement of workers and what happens in that regard. In addition, with safety issues, and maybe it's in here, maybe you said it, Eric, and I just missed it. You know, what about, I guess I get a little concerned about some of our neighbors have a lot of, or neighborhoods have a lot of variance between where you can park on certain streets. And, you know, I get concerned about visibility issues, especially in some of our neighborhoods that there's a lot of cars and lots of traffic going through. And then you've got, you know, Johnson County moms and minivans, that type of thing.
I have met that species before. And so Senator Holscher, it may be easier for the proponents to speak to some of their features and everything. I know they're supposed to have flashing lights and lots of them have things. But again, as I said, as the bill's been drafted, there are no penalty provisions. So if you don't have any of those things, there's nothing anybody can do about it.
Okay. Senator Dahl.
Thank you, Mr. Chairman. Eric, couldn't a municipality pass ordinances to create laws for penalties, as you stated, such that there's not a penalty in the ordinance, as in the bill right now, but couldn't the city themselves?
I'm trying to find the section that we have it. I thought there was a specific prohibition against any of those, and I'll have to go back and look, but I thought the limitation on cities was just to say yes or no to having them in there, but I'll dig further. Normally, that would be the case.
Is this the same bill we had last year? Wasn't there an amendment?
As amended, yes, sir, as
Guys,
amended, yeah, section 3 was the amendment that gave cities some voice in it versus having no voice. And then they can consult.
Other questions? Okay, we'll go ahead and close the hearing on 161. And we will move to, there was a new packet passed out, 176. Chuck, you want to give us an overview on 176?
Thank you, Chairman, members of the committee. Again, I'll try and make this brief. Senate Bill 176 is also a bill that was before the committee last year. Last year it was Senate Bill 168. It was heard in this committee and then went to the Committee on Ways and Means and then back to this committee, but died in committee. This bill pertains to a registration system that is administered and enforced by the Attorney General for the home inspectors. So there's a provision that persons who fail to register, as required by the bill, are subject to civil penalties. Persons who perform home inspections without being registered are also subject to a Class C non-person misdemeanor. The registrants must apply to the Attorney General. The Attorney General can conduct a criminal history record check, and the Attorney General may deny, suspend, or revoke registrations for failure to meet the requirements of the Act. You can see those. You can see that at page 5 and 6 of the bill. The requirements for registrants are that they must be 18, have general liability insurance coverage of $250,000 or more, maintain proof of financial responsibility, either through an insurance policy, a bond, or irrevocable letter of credit. You can find those requirements at pages 7 and 8 of the bill. Applicants previously registered under prior law are considered to have met the education and testing requirements that are set forth in the bill. Applicants who have been engaged in home inspections for at least 2 years prior to their application date and have completed at least 200 home inspections are also considered to have met the education and testing requirements of the bill. However, other applicants must complete an exam, submit evidence of specified education requirements, and they also must complete supervised inspections under the supervision of a registered home inspector. And you can see those requirements at pages 8 and 9 of the bill. There is a long list of exceptions to the requirements of registration. You can see that at page 10 and also page 12, section 17 of the bill. Liability is set at $2,000 under this bill for a home inspection, unless a greater amount is specifically provided to the customer in writing. There's a provision that action for damages must be brought within 12 months of the home inspection. And again, the liability limitation is at $2,000 in the aggregate, unless there's a written exception to that. There's a home inspector's registration fee fund that is created. This is to be used by the AG to administer the program. From, of course, the fees go into that fund. The bill also creates a Kansas Home Inspectors Advisory Council to assist the Attorney General in carrying out this registration scheme. You can see how the advisory council is formed at page 3 and 4 of the bill. There is a sunset in this bill of July 1, 2027. Otherwise, the bill is effective on July 1st, 2021 if enacted. That is a quick review of what the bill does.
Questions for Chuck?
Mr. Chairman?
Yeah, Tom, go ahead.
Yeah, so just a question for Chuck, a request for legislative research. Charles, this bill, obviously, to me, it appears to be pretty close to the final product that we ended up with before the bill collapsed in committee and Senate last year, correct?
I have not had the opportunity to carefully compare that, but as I understand it, this is a product that the stakeholders.
Okay, that's fair. That's fair. And then the other thing would be is that when we talk about last year's work product, that bill originally started out a whole lot different than what it ended up to be, did it not?
That is correct, Senator. If I recall correctly, initially it was actually a licensing provision. And then it has been changed substantially to just be a registration scheme.
Very good.
It's come back like 2 or 3 times, maybe more, Tom. I mean, this bill has been around forever and ever.
Right. For full disclosure, I've been intimately involved with this in the various stakeholders group, and I would also ask legislative research. If you go back to, gosh, I'm really dating myself here once again, unfortunately, but I want to say maybe 20. I can't remember. Maybe some of their senators have been around as long as they can know, but it may be back as maybe as 2010. I don't know. But there was a push, and we actually had legislation, I believe, come from one of the Wichita area-based home inspector groups working in conjunction with the Kansas, I want to say the real estate folks, to basically put together, there were some statutes that were passed, legislation to basically provide some sort of regulation entity between the real estate board and the home inspectors. And I apologize, I'm speaking out of turn here.
We got about 12 minutes, so
okay,
can we
maybe, Mr. Chairman,
hopefully get some of these proponents and opponents done? We're going to go ahead to the proponents. First up, Mark, is it Toom? Let's try to give the opponents a few minutes too, so buzz through this real quick.
I'll be brief. Mr. Chairman, members of the committee, my name is Mark Toom. I'm here on behalf of the Kansas Association of Realtors. Thank you for the opportunity to provide testimony in support of this bill. We've taken the lead role working with stakeholders. It's been an ongoing process to work with the stakeholders who don't always agree on different educational requirements and how education is delivered. And so certainly when you have a compromise, there are some people who may not like every aspect of the bill, but we've worked with the likes of the Kansas Association of Real Estate Inspectors, the Kansas Association of Residential and Commercial Inspectors, the International Association of Certified Home Inspectors, and then also the engineers and architects to craft this legislation. And we believe it is extremely important to provide consumer protections for what is really someone's largest purchase. And this is a bill that would provide a minimum standard of education and liability protections and join 36 other states that have home inspector standards. And we previously had standards. I think you alluded to the long history of this legislation. It was allowed to sunset in 2013. It passed by rather large majorities in both chambers. And it was still allowed to sunset because there was not a veto override attempt at that time. But we believe this legislation is a strong step to really provide, carefully constructed consumer protections. And there's been a lot of harm due to people. Anybody can call themselves a home inspector at this moment, and I could call myself a home inspector, and I would be inferior in that. I would not be qualified. So really recognize the importance of this legislation. And with that, I'll be happy to stand for questions at the appropriate time.
Okay, Carrie Parham, are they here? No? Okay, questions for the proponents? Do we have any? Okay, not having any questions, we'll move to the opponents. Let's go ahead and start with Ralph, and then we'll go to Elizabeth. Go ahead, Ralph.
Thank you, Chairman.
Quick as possible, but yeah, go ahead. You got the
move right along. Thank you, Chairman Olson and committee members, for giving me the opportunity to discuss this bill with you today. My My name's Ralph Pimentel. I own National Building Consultants here in Topeka. 31 years in the home inspection industry. Matter of fact, the first business in Topeka to offer that service. And I was also a member of the Kansas Home Inspectors Registration Board from 2007 to 2013. So I know firsthand how that first attempt to regulate home inspectors turned out. And it is rather unique for this committee to be able to take another look at a bill that's already been tried before so that we can kind of see where we made mistakes and hopefully see where we can make improvements. In 2013, when Governor Brownback decided to allow this statute to sunset, he made the following statements. He said he was going to do so because he believed in smaller government, less regulation, and less intrusion into small businesses. He also said that consumers had avenues for recourse if they were harmed by a home inspection. They had the Attorney General's Consumer Protection Division. They had the court system. In addition, he said that another reason why he decided to let the sunset was because he had received a number of complaints in his office that was filed against one of our board members. And he said because of that, the Home Registration Board had demonstrated that it was not capable of regulating itself, which is a very harsh statement, I think indicative of how poorly that board failed to actually apply the measures of the statute. Eventually, it did result in the then executive secretary of our board being removed. The governor's office asked that we remove Jeff Barnes from that position, and the Attorney General's office provided the board with direction and instructions on how to do that. This bill is very similar in many areas to that statute that was in effect during those 6 years. It also has the very same problems that the previous bill had. It's trying to create an exemption for architects and engineers, and that means there will be a large gap in consumer protection. There'll be a number of homeowners who will hire a registered home inspector and not realize that if it's an engineer and architect, they're not going to be afforded the same level of consumer protection. Engineers and architects are not required to carry liability insurance, errors and omission insurance, nor are they required to be bonded. There are just a lot of shortcomings when you allow this exemption of engineers and architects. Before I came here, I made a number of calls to various state agencies in Texas, Florida, Arkansas, Ohio, Oklahoma, asking each of those officials that oversaw home inspection licensing programs if they exempted engineers and architects, and each and every one of them said no. So Kansas would definitely stand alone in creating this exemption. There's also a couple of constitutional issues with the way the bill is written now. The Attorney General's office provided a legal opinion to our board that stated that we could not delegate our authority to a nonprofit association or to any outside group. It was called the Unlawful Delegation clause in the Constitution. And the previous bill delegated authority to some of these trade associations. It was initially suggested that people would be grandfathered in if they belonged to ASHI, InterNACHI, NAHI, some of these trade associations. And the Attorney General said that's not allowed. And if you look at this bill, you'll see the very same language and the very same attempt to delegate authority from the legislature to these trade associations. And I believe that's a serious flaw. The other omission, or the other change that I think also warrants consideration, the initial bill required criminal background checks, KBI check, fingerprinting. And I think it's important that homeowners have some assurance that people coming into their house are going to be vetted. We're not just going to allow individuals who might have questionable backgrounds to come into their house, be around their personal belongings or their family. In closing, I've always been a proponent of licensing and building regulation. Prior to starting this company, I was a certified building official for the cities of Topeka, established several licensing programs, and I have seen firsthand the direct benefit of licensing. But this particular attempt to regulate home inspectors has too many shortcomings for me to support it. Although I think with the proper amendments, with eliminating that huge exemption for engineers and architects, it's something that the committee should at least reconsider. Thank you for your time.
Okay, I'll allow a couple questions. Do we have a couple quick questions? Not seeing any, I'm going to go ahead and suspend the hearing on 176, and we'll pick it back up tomorrow. We might run a little long tomorrow past noon if, try to get all these bills done up tomorrow. And we'll start off tomorrow by working Senate Bill 126. That's the American Legion's bill. It seemed pretty non-controversial. So 126, member of the American Legions were here, asking to expand be able to sell in their banquet hall. Go ahead. Well, if you want to do it today, we can. Okay, I'll take a motion. Go ahead, Senator Tyson, you got the floor. It's non-controversial. 126 has been moved to put on the consent calendar. Senator Steffens seconds it. Any questions or comments? Senator Peck?
Thank you, Mr. Chairman. The bill is extremely controversial to me, and so, okay, that was all I was going to ask for this time.
To go across the floor? Do you have an amendment or something, or?
Thank you, Mr. Chairman. No, I have and I'll just tell the committee, I have a personal prejudice against any bill that will increase the consumption of alcohol in the state of Kansas. I've seen alcohol destroy too many lives, including in my own family, a brother, an uncle. So I always oppose legislation that will allow for one additional drop of alcohol to be served in the state of Kansas. That's the reason it's controversial to me. Now, I expect it to pass probably 39-1, but just for the committee's information, because alcohol is a controlled substance, and I just oppose anything that, like I say, increases it.
Okay, I respect that. Does someone else want to make a motion on it? She withdrew her motion. You withdrew your second. Go ahead, Senator Dahl.
I move that we move Senate Bill 126 out favorably.
Got a motion? Do we have a second? I'll second it. Any questions or comments? All in favor, please signify by saying aye.
Aye.
Against, nay? Okay, it passes. Do you want to be recorded? Okay, thank you. Okay. Thank you. It passes, and we're adjourned. Thank you.